Level up your firm's productivity, cash flow, and client satisfaction with LawPay. Capture more billable time with start and stop timers, simplify billing by creating invoices using the time tracking entries you log, and streamline payments with online debit, credit, and e-check payment offerings and pay later legal fee financing, which provides your firm with the full payment upfront while clients pay over time. Give your firm LawPay and get a $250 gift card when you sign up by the end of the month and process $500 in your first 30 days. Terms and conditions apply. Learn more by visiting lawpay.com/dcbar. Throughout the year, you work hard to ensure the best client service and win over your competition. This giving season, give your practice the tools to grow with MyCase Plus LawPay. More than 17,900 legal professionals choose MyCase Plus LawPay to streamline payments, automate repetitive tasks, and free up time for what matters most, delivering outstanding client outcomes. Get 25% off MyCase Advanced plus a $250 gift card when you process $500 in your first 30 days with LawPay. Terms and conditions apply. Learn more by visiting mycase.com/dcbar. Treat your personal injury firm to CasePeer this holiday season. From intake to document creation, CasePeer simplifies your firm's workflow, improves client experiences, and reduces admin tasks. And when you complete a live demo this month, you'll get a $50 gift card. Terms and conditions apply. Book your demo and claim your gift at www.casepeer.com.
Welcome to Brief Encounters. I am Lisa Ann Hamilton, co-chair of the Environment, Energy, and Natural Resources Community of the DC Bar. Today, we will discuss recent developments in the environmental justice space. Today, our guest is Julius M. Julius is a principal with the law firm of Beveridge Diamond, where he co-founded and co-chairs B&D's Environmental Justice Practice Group. As a litigator and counselor, Julius represents clients in a variety of industries on a wide range of environmental issues. Whether it's navigating regulatory hurdles associated with contaminated properties, toxic tort disputes, PFAS mitigation, Julius is a leader in designing and implementing solutions and risk mitigation strategies with an eye for environmental justice issues. He is a frequent speaker and author on a number of articles about state and federal developments in environmental justice, and his insights appear in publications such as Law 360, Bloomberg, Inside EPA, and E&E News. So just to give a little bit of context, environmental justice is defined as the fair treatment of all people, regardless of race, color, national origin, income, or any identity in the development, implementation, and enforcement of environmental laws, regulations, and policies. With the dawn of the environmental justice movement dating decades, it wasn't until the 1990s that executive agency commitments to environmental justice under the Clinton administration officially launched responses to the movement. Executive Order number 12898 identified the importance of achieving environmental protection for all communities and recognized the disproportionate impact on minorities and low-income communities. So nearly 30 years later, in 2022, the Biden-Harris administration acknowledged that overburdened communities continue to bear the brunt and disproportionate impact of toxic pollution, underinvestment, and critical services that are likely to worsen with the disproportionate impacts caused by climate change. I'm so glad today that we have the benefit of Julius's expertise to help us navigate this dynamic moment in environmental justice. Welcome, Julius.
Hello, Lisa. Thank you very much for inviting me, and thank you to the DC Bar. I appreciate this opportunity and the platform.
We're delighted to have you. So let's get started. You have clearly been a pioneer in the space as co-founder of the practice for Beveridge Diamond. What inspired that decision to launch an environmental justice practice group?
Excellent question. As you sort of eloquently noted in your opening, I have a wide-ranging environmental practice, both me personally and my firm writ large. And we really saw the need for private sector practice that incorporates environmental justice from the perspective of industry. Given our client base, we had the natural platform to initiate sort of these conversations with our clients. And we sort of saw an opportunity to advance environmental justice while working with our industry clients. We didn't see really any other private sector firms practicing in this space. And so we, in 2015, during the prior administration, our former managing partner and my mentor, the incomparable Ben Wilson, one of my other colleagues, and I officially launched the firm's environmental justice practice. We have been doing this work for years, but just not in a formal space. And at that time, we thought it was appropriate to formalize our practice and really proactively approach our clients and offer counseling service with respect to proactive consideration of environmental justice as we represent the interest. Back then, we were sort of had to persuade industry that it was important, at least some in industry anyway, that it was important and that it sort of made business sense to proactively consider these issues as they operate their businesses. Now, sort of pendulum has swung the other direction where clients are seeking us out specifically to help guide them through these issues.
That's right. I have to tell you, I didn't realize it was as far back as 2015, but it seems pretty prescient given the Biden-Harris administration's initiatives beginning in 2022 when they signed Executive Order 14008 to tackle the climate crisis that included a strong environmental justice focus. And just if you'll bear with me to run through some of those really landmark initiatives. They established the White House Environmental Justice Interagency Council, the first ever White House Environmental Justice Advisory Council, the Justice 40 Initiative, which aims to provide at least 40% of overall benefits of federal investments relative to climate change, clean energy, among other areas, to reach marginalized and underserved communities, as well as the development of the CJEST, or Climate and Economic Justice Screening Tool, to help agencies identify disadvantaged communities. And so you mentioned this huge interest now from industry, probably, but want to hear from you, due in part to the tremendous investments under the Bipartisan Infrastructure Law, as well as the Inflation Reduction Act. How are you seeing these issues come together in the course of advising your clients?
Sure, a great question, Lisa. With respect to those pieces of legislation, specifically the Inflation Reduction Act and the Bipartisan Infrastructure Bill, these laws in and of themselves sort of build in mechanisms to prioritize funding in disadvantaged communities. As you mentioned, under Executive Order 14,008, it includes the Justice 40 initiative, which has the goal of ensuring that at least 40% of overall benefits from certain federal climate-related and clean energy investments go to disadvantaged communities. The executive order also directed the White House Council on Environmental Quality to develop a tool to be able to identify the disadvantaged communities. And the Climate and Economic Justice Screening Tool is the method by which the Council on Environmental Quality has developed to easily identify disadvantaged communities using the prescribed criteria. And we've seen that manifest itself in a number of different ways. Sort of agencies are taking a variety of approaches in delivering funding under those laws. At the Department of Energy, for example, they require the development of community benefits plans for nearly all of the agency's funding under those two pieces of legislation. Community benefit plans in general require a detailed analysis of the project's impacts, a thoughtful and equitable distribution of the project benefits, and sort of significant, meaningful engagement with communities on many, many different aspects of each project that is funded under those pieces of legislation. And when an applicant is selected, their community benefits plan becomes a part of their contractual obligation in receiving and using those funds. We have worked with various clients in completing community benefits plans, and we think it has the potential to really ensure the delivery of benefits to disadvantaged communities.
That's fantastic. And especially where community engagement had been talked about as a principle, it's nice to hear that through these programs, clients are adopting it as a fundamental part in how operations are executed and hopefully will become part of best practices. So between the investment, between the congressional action, so that there are now billions of dollars committed to clean energy rollout, to energy investment and environmental stewardship, at the same time, in the courts, we're seeing a very different dynamic. We're seeing unprecedented challenges to the interpretation of what discrimination is and executive agency authority in the permissible scope of DOJ and EPA exercise, and a new definitions of disparate impact under Title VI of the Civil Rights Act. Can you take us through those recent developments and maybe talk a little bit about the Louisiana v. EPA case?
Ooh, so how much time do we have for this podcast?
It's a big question.
Right. I'm only kidding. So, sure, I will discuss a little bit about the Louisiana versus EPA case, sort of hit the highlights. As you might imagine, there is a very long history that I don't think that we have the time to really explore in detail. But in general, it relates to the filing of complaints under Title VI of the Civil Rights Act of 1964. Certain organizations filed complaints with the Louisiana Department of Environmental Quality and the Louisiana Department of Public Health related to their administration of certain programs with respect to the approval of permits related to certain facilities in a particular section of Louisiana referred to as the industrial corridor. The industrial corridor is the area largely between Louisiana and Baton Rouge that has a significant amount of industrial operations and facilities. EPA accepted, I believe it was 3 Title VI complaints related to that sort of background that I just described. EPA's investigation of those complaints were consolidated to all be investigated together as the parties, LDEQ, or Louisiana Department of Environmental Quality and Louisiana Department of Public Health, and EPA were involved in the informal resolution process. In May of 2023, the state of Louisiana, on behalf of those agencies, filed suit against EPA, Department of Justice, and other federal actors seeking to ban the enforcement of both EPA and DOJ's Title VI disparate impact regulations. In January of 2024, a judge in the U.S. District Court for the Western District of Louisiana granted the state of Louisiana's preliminary injunction motion, effectively precluding EPA and DOJ from enforcing the disparate impact regulations under Title VI in the state of Louisiana. And thereafter, in August of 2024, the same judge issued a permanent injunction barring EPA and DOJ from enforcing the disparate impact regulations under Title VI in the state of Louisiana. About a week after that permanent injunction was issued, in Michigan, the Department of Environment, Great Lakes, and Energy entered into a Title VI agreement with certain organizations that had filed a Title VI complaint with that agency. Typically, that would be unrelated to actions in Louisiana, but what happened here was after the judge issued that permanent injunction, the state of Louisiana went back to the same judge, asking him to essentially modify his order so it doesn't only permanently ban EPA the DOJ from enforcing Title VI disparate impact regulations in Louisiana, but they asked him to expand that ban so it applies nationwide. And one of the reasons cited, let's say Louisiana cited for their application asking the judge to expand that ban is the agreement reached in Michigan. So that as we sit here today in October 2024, we are waiting for the judge to rule on Louisiana's application to expand that ban nationwide.
Wow, thank you for providing us that explanation. So this could have some far-reaching implications nationwide on the use of disparate impact. And at the same time, we're seeing in those cases a variety of challenges to EPA's authority to enforce environmental laws. We're seeing some really positive developments at the state level. Could you talk a little bit about some of the state developments in environmental justice and how you think that may impact the future of the enforcement of environmental justice and protections for overburdened communities?
Absolutely. I mean, I think in the environmental justice space, sort of states have been that proverbial laboratory of experiment. We have seen various states implement regulations, both regulations and policy and statutes, to advance environmental justice in various ways. New Jersey is, I guess, in recent times, certainly one of the leaders in those efforts. In 2022, the state legislature passed what's sort of widely viewed as landmark environmental justice regulation because it empowers the state's Department of Environmental Protection to deny permits for certain facilities largely on environmental justice grounds. The regulations for that statute were finalized in 2023, and it requires sort of many different things, but one of which is the evaluation of prescribed environmental stressors on overburdened communities. And it empowers DEP to adjust the requirements of the permit applications to respond to potential impacts on overburdened communities. And while that's in New Jersey, we also seen efforts in New York, we've seen efforts in Massachusetts with respect to cumulative impacts. Of course, California has long been a leader in this space. We've seen efforts in Colorado. So there are certainly many different states in which we have seen efforts to advance environmental justice. Even in the Pelican state of Louisiana, where we're just discussing this landmark litigation with respect to Title VI, their appellate court ruled earlier this year that under the state's public trust doctrine, environmental justice is sort of inherent within that doctrine from the state. So we have certainly seen states advance environmental justice in various ways, even though there has been some retrenchment with respect to Title VI.
That's really helpful. Thank you for that. And just out of curiosity, what sort of piques your interest in the year ahead? What are sort of the developments that you're watching for, in addition to this question about whether disparate impact under Title VI will apply exclusively to Louisiana or nationwide?
Yeah, I mean, that's certainly one of the most significant events on the horizon that I'm watching to see how it impacts industry and specifically how it impacts EPA and DOJ's ability to enforce disparate impact regulations under Title VI. The upcoming federal election is another sort of significant milestone that we are watching to evaluate the impacts on environmental justice. As we sit here in October, we're about 3 weeks or so from the election. So depending on how the federal election goes, there will almost certainly be significant impacts with respect to environmental justice. As you sort of thoughtfully laid out at the beginning of this episode, it has very much been the Biden-Harris administration that has advanced environmental justice. Many of the ideas with respect to environmental justice that we've seen this administration implement had its roots in the 2019, I guess, primary campaign of then Senator Harris. So we will anticipate perhaps a continuation of some of the policies if she were to be elected to the White House. And conversely, we don't know precisely what a Trump administration would do with respect to environmental justice, but we can likely anticipate that it would not advance environmental justice initiatives to the same level as the Biden-Harris administration has. That's sort of at the federal level. At the state level, as we discussed, there are efforts throughout the nation to address environmental justice in different ways. So sort of continuing to stay abreast of what the states are doing and how they are addressing environmental justice through their efforts is certainly a place to watch as well.
Excellent. Well, thank you so much. We look forward to watching current developments, including the election. I want to thank you so much for your time and expertise and for sharing your insights with us this afternoon.
Thank you for having me. Much appreciated.
This episode of Brief Encounters has been brought to you in part by our sponsors, LawPay, MyCase, and CasePeer. Learn more about these solutions in the description of this episode.